The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good afternoon. We have 3 cases that will be submitted. Those cases are State of Iowa versus Ernest Bynum. The second case is Deborah Ferguson versus Exide Technologies, Inc. and Fred Gilbert. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Edward Noyes. That last case is now submitted to the court without an oral argument, and we'll first hear the arguments in State versus Bynum. Mr. Meyer.
Good afternoon. May it please the court and Ms. Hall. My name is Mark Meyer. I'm appearing on behalf of appellant Ernest Bynum. On March 10th of 2016, Mr. Bynum called the Cedar Rapids Police Department and told them that he had observed a vehicle park at a residence in Cedar Rapids, observed 1, maybe 2 men exit the vehicle. 1 or both of them had firearms, is what he reported. They approached a residence, knocked on the door, and entered. So the question presented for review is that the text of Iowa's carry weapons statute, which is Iowa Code Section 724.4, begins with the phrase, except as otherwise provided in this section, and then goes on to provide that a person who carries a firearm in a city violates the law. One of the exceptions to Chapter 724.4 is that a person that has a valid permit to carry a firearm can carry a firearm in a city or town or most any other place.
I want to cut to the chase on that. On that carrying weapons statute, is it your position that the exception for a permit is not an element of the crime?
Well, I'd lose on that based on the current Supreme Court law. It's an affirmative defense.
Okay, that's what I wanted to get to. And then the next question I had was, well, actually, go ahead. I'm going to let you go ahead before I ask the next one. Go ahead.
Okay. So whether you characterize having a valid permit as being an element, which I'm not, or an affirmative defense, the jury in this case was instructed that it's always illegal to carry a firearm in a town.
Here's the thing. The statute makes it a crime to falsely report a criminal act. And what we have here is something that would sometimes be a criminal act and sometimes wouldn't be. It doesn't make it a crime the way maybe the state would characterize it, to falsely report the prima facie elements of a criminal act. It says criminal act. So what do we do with that language, criminal act? How do we handle that in front of the jury?
Well, I would suggest that we give them enough information so they can do their job, so that they know that sometimes carry a weapon in a city is a crime and sometimes it's not. They weren't told that, though.
Now I want to go to my next question. Okay. If it's an affirmative defense, wouldn't that be on the burdens, on the defense's obligation to, as you said, give them enough information to go from? Was there any information presented by the defense regarding the permit situation other than a couple little questions on cross-examination?
What the evidence was relating to what Mr. Bynum reported is that he simply said that he saw 1 or 2 men exit a vehicle. He didn't say, I saw 1 or 2 men who didn't have a permit.
So was there enough evidence presented for the court to warrant giving a jury instruction? If that's the theory of the defense's case, do you believe that there was enough evidence presented for the court to consider an instruction on that?
I don't. No, I don't think the judge should have given that instruction. I don't think the judge should have given the jury the option of finding that that Bynum reported the offense of carrying weapons.
Your view is the jury should have been told more about the statute than what they were told.
Exactly, right. Essentially, the way the jury was instructed, the judge, in effect, directed a verdict for the state. And if the report is that two men exited a vehicle carrying a gun, and the instruction tells the jury that if you carry a weapon in a city, you've committed that offense, and basically the jury has no reasonable, logical reason not to convict. Right? They're told, what Bynum reported is a crime.
We're doing a bunch of pretends here, aren't we? I mean, we're pretending there were two guys leaving a vehicle. I mean, it seems to me the evidence was pretty clear that there was a false report. It's just a matter of whether or not it was about a crime. Is that correct?
That's exactly right. It's a crime to make a false report, period. Right? That's a simple misdemeanor. But if the report involves a crime, and not just any crime, but an indictable misdemeanor or felony, then the penalty is enhanced. So it's always a crime. So I'm not claiming that Mr. Bynum's not guilty. The argument is that he's not guilty of the penalty enhanced version of the offense.
And that's because the imaginary men might have had imaginary permits for their imaginary gun?
Yeah, exactly. And that's exactly the argument. So I'll just reserve, that's the crux of the argument. I'll reserve any additional argument for rebuttal.
Thank you, counsel. Ms. Hall.
May it please the court and counsel. The state is arguing that the district court and court of appeals correctly found that an exception for having a valid permit to carry a weapon was not relevant to the offense of making a false report to a public safety entity. False reports.
So if they actually had the permit, he would still be guilty of the enhanced offense?
Yes.
And how is that?
False reports is a crime against the government requiring proof that the defendant reported the alleged occurrence of a criminal act knowing the act did not occur. The defendant's focus on whether or not the alleged criminal act actually occurred is misplaced. Having a permit is a defense that only a person charged with carrying weapons can raise.
Oh, but that's right, if that were the charge. But the question is this, as Justice Waterman said, is this scenario that was reported, that we all agree was false, is this scenario that was reported, was it a crime or not? Was it a criminal act or not? And doesn't the jury have to be given the option of concluding, well, gosh, most people who carry weapons have permits for them, and maybe these people did, and therefore it wasn't a false report of a crime. Why couldn't they have been entitled to conclude that?
Well, perhaps there might be some factual scenario where the defense had provided sufficient evidence to warrant an extra note about having a permit. But as Justice Christensen said, there were not two men with two guns. Therefore, whether they had a permit or not is not really relevant. The jury was asked to decide whether the report met the general definitions that were given for carrying weapons or burglary or going armed with intent in Instruction 13. The general definitions were provided in Instructions 14, 15, and 16. All three of those were offense levels above simple misdemeanors.
Let's say that they did have a gun, and they did have a permit. None of this, thing. And so if somebody sees someone walk into a house with a gun, and they have a permit, and the same report's made, is there a crime of carrying a gun in the city if they have a valid permit?
Perhaps not if the evidence shows that the defendant accused of making a false report truly believed that a crime was being committed, then he or she would not be guilty of making a false report.
What if the person who made the report knew the person carrying the gun had a permit?
I still don't think it makes any difference to the person charged with false reports. If jurors were instructed without objection in Instruction 17 that the state was not required to prove the elements of those three offenses. So why would be...
let me follow up on Justice Wiggins' hypothetical. Let's assume I make a false report of somebody I know, and in fact, Bynum knew, apparently, these individuals. I make a false report of somebody that they're carrying a weapon when I know they're not carrying a weapon. But I also know that they have a permit for that weapon. Have I made a false report of a crime?
I think so. I think you're getting too far off.
What's the crime?
False reports.
In the hypothetical.
Making a false report.
Well, what's the underlying crime that's being reported? If I know that they have a permit, and I say falsely that they were on the lawn or at the house, it's false. It's a false report under the first prong. But what's the criminal act if I know that they have a permit? It's not a carrying offense under the statute.
Then I think you could still be guilty of making a false report.
Agree, and I think counsel concedes that. The question is whether they're liable for the enhanced crime.
If the jurors had found the state had not proven the defendant reported one of those three crimes, the third element, but had proven that he simply reported a criminal act that did not occur, he would have been guilty of the lesser offense. But the jurors signed verdict form number 1 and marked carrying weapons, which is the higher serious misdemeanor offense. Had they chosen verdict form number 2, that would have meant the defendant was only guilty of the simple misdemeanor offense. The state notes that if the reporting person believes a crime is being committed, whether simple misdemeanor or greater, then it is not a false report and that person is not guilty. Thus, the proposed exception to carrying weapons does not help this defendant. There's no factual support in this record that the defendant actually believed a crime was being committed involving weapons. I noticed in the defendant's further review application, he throws in a Apprendi claim for the first time. And again, we don't have an Apprendi problem in this case. The third element, the state having to prove one of those three crimes that could possibly had fit into the general definitions that were given, that was submitted to the jury and decided by the jury. It was not in any way directing a verdict for the state.
Say I make a falsely report. I see that somebody is breaking into a house, and I say that I've seen someone breaking into the house. I haven't actually seen that next to a house next door. It turns out it's the neighbor that's breaking into the house. Have I made a false report of a crime if I just say I saw so-and-so breaking into a house? They broke into their own house?
I think the key is the knowing element, that you're reporting a criminal act that you know did not happen or is not happening.
I'm going to play the pretend game too. There's so much pretending, it makes my head spin. I'm having a hard time grasping the fact that what was called in, apparently the officers believed could be carrying a weapon amongst two other crimes. That was one of the three, correct? And now the defense is bringing up, but what if there's a permit? Isn't that kind of like if I'd call in a murder? I mean, everybody knows murder when you hear it. That's certainly an indictable offense. And then come to find out, guess what? There's no body. Or maybe there's a perfect alibi. Whether or not the pretend defendant would be successful in his conviction, aren't we just looking at the charge? Is it a crime? Whether or not it's going to be a successful crime. That's where I'm having a hard time with the affirmative defense. Can you help me out on thinking that through? Do you think there really needs to be an actual, I mean, if we're going to talk about a permit, that's just, once again, pretending.
No, it doesn't have to be an actual criminal offense. I mean, all the elements and any defenses that might apply. The gist of it is, did the person calling in an alleged criminal act know that the act reported did not occur?
Isn't that just part of it? They have to also know that it was a criminal act. They also have to be reporting a criminal act. What was described here is sometimes a criminal act and sometimes not. And shouldn't the defendant be able to say, well, what I called in was not actually a criminal act most of the time, or a lot of the time, because a lot of people have weapons permits when they're carrying weapons.
But if we go down that road, should we have also submitted some defenses to burglary or going armed with intent? Intent, lack of intent, justification, right or privilege to enter.
In this
How can you
case,
prove
on
a
the
negative?
record, what did the defendant say when he called in? Did he say, I may or may not be reporting a criminal act, but I want you to know that these people are carrying guns and they may or may not have permits? I don't know.
He didn't mention permits.
What did he say?
He said there were two black men that pulled up in a vehicle and parked over the sidewalk, jumped out of the vehicle. One had a handgun, one had a rifle, went up to the door, knocked, and entered. The knocking part was not relayed to the officers from the dispatcher. When asked a couple more questions, he said he did not know the resident, which was not true, and that he had not seen the vehicle there previously, which was also not true. The defendant had been living there for quite some time with Pamela Haskins, their teenage son, and it was Haskins' older son that was
So this defendant didn't call in and report a crime specifically identified. He didn't say, I see two people committing the offense of carrying weapons. He falsely reported a fact pattern, and then the prosecutor here selected the crime that would fit the enhanced offense based on what this defendant falsely reported. Is that right?
Correct.
Okay.
But the jury did have the option to find that he had not reported one of those three crimes.
How, under the instruction that was given, once they found that the report was made and it was false, wasn't the conviction a foregone conclusion under that?
He could have been convicted of the simple misdemeanor level.
Well, it was submitted, but the instruction still wouldn't allow the argument that what I reported was sometimes a crime and sometimes not. Instead, the judge said, in effect, if Bynum made this report, it was a crime.
Again, you can make that argument with any of the crimes submitted, that it might not have been burglary.
Burglary is a little hard to show. They had weapons apparently, but walked in the door. Is that the occurrence of burglary? Has he reported the occurrence of burglary? He's reported armed men walking through a door.
I thought the only one he was convicted of was the false report of carrying weapons. Right.
Yes, that's true. Just real quickly, turning to the fair cross-section claim. That claim fails for three reasons. First, it was untimely. There was no objection to the fact that the civil case ended up using all 35 jurors first who had showed up that day. There was no motion to strike the jury panel of 21 that was left over, no motion for continuous. Instead, defense counsel proceeded with jury selection and waited until the next morning to assert a due process claim and move for mistrial. That is unlike this court's recent opinions on fair cross-section claims. Second, defense counsel conceded that the jury pool met the plain standard. She had reviewed jury questionnaires and determined that 2 African Americans were among the group of 35 that were being called in. Thus, defendant could not establish the underrepresentation prong on this record. Third, if the second prong's not met, it therefore follows the defendant cannot establish systematic exclusion resulted from Lynn County's jury management system of compiling jury pools. The present record found in pages 14 to 18 of transcript volume 2 is incomplete as to why only 35 persons were present for 2 trials that day. But it does appear that the civil case was ready for jury selection before Mr. Bynum's case, which was occupied with pre-trial motions, the first 20 pages of transcript volume 1. Defense counsel even admitted that it was no fault of the court that the reshuffling of the jury pool happened. If this defendant wishes to challenge Lynn County's jury management practices, he's free to raise that in a post-conviction application under an ineffective assistance claim for waiving error.
Okay, I'm not troubled by that claim, but let me raise one of the issues that did bother me, and this was the photographs of the weapons. Now, I read your brief on appeal, and you say evidence of the level of law enforcement response was relevant to show why the legislature has found it appropriate to punish the false reporting of a fire or other emergency that poses a danger to the safety of all persons. Now, normally, we don't let the state bring in evidence to show the reason why a criminal law has been enacted, right? That's usually kind of a prejudicial use, wouldn't it be?
I don't think that was put before the jury.
But I mean, I have trouble seeing why the photographs of the weapons would have been pertinent or relevant in this case.
The prosecutor was just trying to show the seriousness of the report that prompted officers to speed over there, armed, guns drawn when they surrounded the house.
That's relevant to what element of the offense?
The photographs? I don't know that I can answer that, but there was no objection to the officer's testimony that explained how they responded and why they responded with a Code 2 and the weapons that they were using.
I see it's a red light, but I'm going to ask a question anyway. I'm not too concerned with either of those issues that were brought up. I want to get back to the one that you did a really nice job of distancing yourself from, the pretend talk. Was there any evidence presented that would warrant, in your opinion, a jury instruction on the affirmative defense of a permit?
No, Your Honor.
Thank you.
State would request the court affirm the defendant's conviction. Thank you.
Ms. Hall, thank you as well. Mr. Meyer may present your rebuttal.
To address the question of the photographs of the gun, what guns the police officers brought, which seems not to be particularly relevant to a charge of false report. It's my understanding that the prosecutor's original theory was that you would judge what the level of offense was based on how the police responded. It's kind of it doesn't find any support in the text of the statute. It's kind of a creative argument that was not, whether or not that theory was going to be allowed was not decided until partway through the trial. So I think that's possibly why the court allowed that evidence to come in the first place. So the judge ultimately decided, no, it's going to be the statutory definition of the offense that's going to determine the level of the response, not how the level of the police. But in the meantime, this evidence about how the police responded came in, which I agree it was quite prejudicial.
Well, but part of it you didn't object to, I gather. I mean, the fact that they responded with guns drawn and so forth, that came in. What the photographs are I don't know, AK-15s or AK whatever they are. They're heavy weapons. How does that prejudice you in light of the fact that some of the police officers were allowed to testify orally about the response?
Well, I think there was an objection, wasn't there, to the introduction of the photographs of the...
Photographs, absolutely, but there was testimony about the manner in which the officers responded, which included the fact that they were armed, I believe. Correct me if I'm wrong.
Yeah, I think they did testify that they responded with... So that's one thing, but to allow the photographs of the weapons is another. I think the judge said, well, they're just photographs, and people see guns all the time, so it really didn't make that much difference. But I certainly could have prejudiced the jury against Mr. Bynum. But I think the real question is, to my mind, the way the jury was instructed. And if I could just...
Can I return to that issue again real quick? So I want to make sure I understand the full extent of what you're asking for. So let's use burglary as an example. And assume somebody calls in a burglary where there are no people entering a home. It's just a false report. I see across the street that 2 people are entering my neighbor's house, and there really aren't 2 people. The person is charged with false reports. Is it your contention then that because in some circumstances those people could have had permission from the homeowner to enter, and that was not a crime, that the state needed to put on evidence showing that people who did not exist may or may not have had permission to enter this home? And if not, why is that different than the carrying weapons case?
Well, I don't think the state has to put on evidence to prove something that was falsely reported. I mean, that's, you have to, and it's my way of thinking, you have to look at what does the report say? And does...
I'm asking you, in that fact pattern, is it your contention that either the state had to put on evidence or this instruction should have said something like, sometimes people have permission to enter homes, and as we're weighing whether or not these people who didn't exist, who didn't enter the neighbor's home, may or may have not had permission, that's a jury question? Is that what you're arguing?
My argument is you look at the facts alleged in the false report on one hand, you compare that to the statutory elements, or in this case, the exceptions to that can be an element or like an element, and then if there's not a match, then it's not a false report.
So your point is the jury, it's not the state's burden, but the defendant should at least have the option to ask the jury to be told about possible defenses. Is that what you're saying?
To have a realistic understanding of what the law actually is.
But in order to get that instruction, don't you as defense attorney have to put on evidence?
If we were presenting a defense to the charge of carrying weapons, right, we'd have to put on some evidence that the person had a permit, right? But that's a different question than can a jury be instructed that it's never legal to carry a weapon in a city, which is what happened here. So thank you very much for your time. I appreciate it.
Mr. Meyer, thank you as well. The case of State versus Bynum is now then submitted, and we'll next hear the arguments in Ferguson.